Hello, welcome to the first in the series of Woolful and Stone's info vids for property managers. In this series of videos, we'll be talking about issues that are relevant to property managers from a legislative or a tribunal point of view, and other areas that may be of interest or confusion for property managers, with the aim of educating you a little bit more and giving you a bit more information to help you understand what you need to be doing in your jobs on a daily basis. Today, being the first in our series, I want to deal with an issue that seems to create a bit of confusion amongst property managers, and that confusion is justified. It can be a daunting and confusing process to work out exactly when you should be going to the Magistrates Court rather than making application at VCAT under the federal jurisdiction issue. There's a number of issues that we need to take into account. I want to focus on trying to bring that down and making it much more simpler to understand where you need to be going. Have a look at 3 basic questions that you need to ask in relation to the issues you've got to determine where you need to make your application. The first of those questions is, where do they live at the time of the application? The second, is a company involved? And the third, only think about the Australian states. So what you need to be thinking about there is Western Australia, South Australia, Tasmania, Victoria, New South Wales and Queensland. Do the parties live in 2 of those states? One in one of them, one in the other. That's the 3 questions. Boil it down to them and you should find it a lot easier to determine where you need to be going. I want to run through some examples for you to give you a bit more of an understanding. So where do they live at the time of application? It's really important to understand this does not just apply to landlords living interstate. This applies to either of the parties living in a state other than Victoria. And the reason for that is that VCAT will determine where the application should be heard based on where the parties were living at the time of application. For example, the lease is finished and you've done your condition report. By the time you've done your condition report, done your negotiations and are ready to make application, the renter may have moved to live in a different state. You then need to be considering where the renter lives as part of your determination where you need to take this matter. The second issue is a company involved? The basic thing here is that both parties need to be individuals. Companies are not subject to the federal jurisdiction issue. So as soon as one of the owners, either the owner of the property or one of the renters is a company, the matter should be heard at VCAT. So for example, with a self-managed super fund, if the self-managed super fund has been set up correctly, the ownership of the property will be in a company name. Automatically, regardless of where the parties actually live, that will be heard at VCAT. So make sure, first question, does this involve both parties being individuals? If it does, then it may be subject to the federal jurisdiction issue. As soon as a company is involved, federal jurisdiction is not an issue to consider. The third question you need to be asking is, only think about the Australian states. So we've got 6 of them: Western Australia, South Australia, Tasmania, Victoria, New South Wales and Queensland. If the parties live in different ones of those states and they are individuals, it will be a matter to be heard in the Magistrates Court, not to be heard at VCAT. I want to explain some issues there because this can also add a little bit of confusion for people. So let's first have a look at what doesn't make it a federal jurisdiction issue. If either one of the parties live in an Australian territory, such as the Northern Territory, the Australian Capital Territory or Jervis Bay, for example, or a few smaller territories like some island areas and so forth, the matter will be heard at VCAT because it doesn't involve people living outside of the states of Australia. As with an overseas resident, those matters where one of the parties is living overseas, again, will be heard at VCAT. It's only where the parties live in different states. So generally speaking, it's going to be the owner living interstate. You've got the renter lives in Victoria and the owner lives in one of those other states. Those matters to be heard at the Magistrates Court. But let's take a look at another example. The lease is finished. The owner lives in Victoria, but by the time you make your application, the renter is now living in Western Australia. That will need to go to the Magistrates Court. Another example, the lease is finished. The owner lives in New South Wales. By the time you finish and make your application, the renter has also moved to New South Wales. Whilst neither party lives in Victoria, they are both living in the same state, and that matter will be heard at VCAT. People have asked, why isn't that heard at NCAT if it involves two lots of people living in New South Wales? And the simple answer to that is because we're dealing with Victorian legislation, and it's VCAT that has jurisdiction over Victorian legislation, not NCAT. They only have jurisdiction over the New South Wales residential tenancies legislation. So basically 3 questions to summarise. Where do they live at the time of the application? Is a company involved? And making sure it only involves 2 different Australian states. Territories overseas don't matter. It's different Australian states. Hopefully this helps. Hopefully it's taken away some of the confusion. We will have more of these information videos coming out soon. Hope you get a bit of information out of it. Hope they're useful. We'll see you again later. Thank you.